Welcome to Chapter 6. Let me start with a statistic that shapes this entire chapter. A huge share of data breaches today originate not inside organizations, but inside their vendors. Your data is only as safe as the weakest partner touching it. That's what today is about. Here's our path. First, due diligence. How to vet a processor before you hand over a single record, because the GDPR says you may only use processors providing sufficient guarantees. Then, we revisit the Article 28 contract, this time from a practical negotiation angle. Next, the relationship after signing. Ongoing monitoring, audit rights, and the tricky world of sub-processors. The vendors your vendors hire, often without you noticing. From there, we shift to sharing data with independent third parties. What legal basis do you need? What must your privacy notice say? What obligations land on the recipient? And we close by drawing the line between domestic sharing and international transfers. Because sending data to a partner in Paris and a partner in California are legally very different acts. Think of this chapter as learning to be a careful host. You decide who enters your house, what rooms they access, and you check on them while they are inside. Let's begin. Let's start before any contract is signed, at the moment you're choosing a vendor. The GDPR sets the bar in Article 28. You may only use processors providing sufficient guarantees that they'll meet the regulations requirements. Sufficient guarantees. That phrase makes vendor selection itself a compliance act. Think of it like hiring a babysitter. You wouldn't hand over your child to someone just because their price was lowest and their website looked nice. You'd ask for references, check their background, maybe visit their home. Personal data deserves the same care because once it leaves your systems, your control shrinks, but your responsibility doesn't. So what does real due diligence look like? Assess the vendor's security posture. Do they hold certifications like ISO 27001? Can they show a recent SOC2 report or penetration test results? Ask about their breach history and listen carefully to how they answer. Transparency about past incidents is often a better sign than claims of a perfect record. Map their sub-processor chain. Who else will touch your data? And check data locations, because a vendor with servers or support teams outside the EEA quietly drags you into transfer territory, which we'll cover in later chapters. Here's the accountability angle. Document the assessment. When I ran vendor reviews for a financial services client, every evaluation went into a risk register with scores and evidence. 2 years later, a regulator asked exactly how one vendor had been chosen. We opened the file, case closed. And remember, due diligence isn't a one-time gate. Vendors change, get acquired, cut corners. Reassess periodically, especially your high-risk ones. We met the Article 28 contract in Chapter 4. So today, let's treat it from the practitioner's chair, the negotiation and review perspective, because you'll spend real hours of your career on these documents. The non-negotiable starting point. A written, binding contract must exist before processing begins. Not after go-live, not once legal gets around to it, before. I've seen projects paused days before launch because someone finally asked, "Where's the DPA?" Better late than never, but better early than late. The contract must describe the processing, subject matter, duration, nature and purpose, data types, and categories of individuals. Here's a practical tip. Push for specificity in these annexes. Vague descriptions like various business data protect nobody and irritate regulators. Name the systems, name the data categories, name the retention. Then the mandatory clauses. Documented instructions only, including for transfers. Confidentiality commitments for staff. Article 32 security. Sub-processor authorization. Assistance with data subject rights, breaches, and impact assessments. Deletion or return at contract end, and audit rights. Now, where do negotiations actually get sticky? In my experience, 3 places. Audit rights, vendors want questionnaires only, controllers want inspection powers, and the compromise is usually tiered rights, reports first, on-site audits for cause. Breach notification timelines, push vendors from vague promptly to a defined hour count. And liability caps, which the GDPR doesn't regulate, but which determine who really pays when things go wrong. Read those clauses like your budget depends on them, because it does. Here's a question I ask every compliance team I train. You did brilliant due diligence 3 years ago. How do you know your vendor is still the company you assessed? Silence usually follows. That silence is the gap this slide fills. The GDPR expects controllers to verify processor compliance throughout the relationship, not just at the start. Companies evolve. Your vendor may have been acquired, moved data centers, laid off their security team, or onboarded risky sub-processors. Yesterday's safe choice can quietly become today's exposure. So, what does ongoing monitoring look like in practice? A layered approach works best. At the base, annual questionnaires and certification renewals. Is their ISO certificate still valid? Is the latest SOC2 report clean? In the middle, reviewing what the vendor publishes, incident disclosures, sub-processor change notices, security bulletins. And at the top, for your highest risk vendors, actual audits, whether conducted by your team or an independent assessor on your behalf. This is why the audit clause you negotiated matters so much. Article 28 requires processors to make available all information necessary to demonstrate compliance and to allow and contribute to audits. Without that clause exercised occasionally, it's just decorative text. Let me share a pattern from a project with a healthcare client. We tiered vendors by risk. Critical vendors handling patient data got annual deep reviews. Medium risk vendors got questionnaires. Low risk got certificate checks. Sustainable, defensible, documented. When monitoring finds problems, feed them into remediation plans with deadlines. And if a vendor won't fix serious gaps, that's what exit clauses are for. Trust, but verify, then verify again. Now for the layer most organizations forget until it bites them. Sub-processors. These are the vendors your vendor hires. Your email platform runs on someone's cloud. Your payroll provider uses an offshore support team. Data flows downhill and every level adds risk. The GDPR's rule is clear. A processor cannot engage a sub-processor without the controller's prior written authorization, which comes in two flavors. Specific authorization means you approve each sub-processor by name, maximum control, maximum administrative burden. General authorization means you approve the concept and the current list, and the processor must inform you of intended changes, giving you the opportunity to object. General is what most cloud contracts use, and here's my field advice. Subscribe to your vendor's sub-processor notification lists. Those quiet emails announcing new sub-processors are your objection window ticking. Two more rules protect you down the chain. First, flow-down obligations. The processor must impose the same data protection obligations on its sub-processors through back-to-back contracts. Your protections shouldn't dilute with each level. Second, liability stays put. The original processor remains fully liable to you for its sub-processor's failures. They can't point downstream and shrug. Here's a story that makes this real. A client discovered during a routine review that their ticketing vendor's sub-processor had a support center in a country with no transfer mechanism in place. Nobody had lied, nobody had checked. 3 contract layers deep, a compliance gap sat waiting. Map your chains all the way down. Visibility is the whole game here. Let's now shift from processors who work for you to genuine third parties, independent organizations receiving data for their own purposes. And here's the mental reset this requires. Disclosure is processing. Handing data to another company is itself a processing operation. And like every processing operation, it needs its own legal basis. I emphasize this because of a misconception I hear constantly. We collected the data lawfully so we can share it. No. Collection had a basis. Sharing needs one too. Think of it like a house key. Being allowed to hold the key doesn't mean you can copy it for friends. So which bases work for sharing? All the Article 6 candidates are theoretically available. Consent, where the individual agrees to the specific sharing, common in marketing partnerships. Contract necessity, sharing your address with the delivery company genuinely necessary to fulfill your order. Legal obligation, reporting employee data to tax authorities. And the workhorse, legitimate interests, which demands a documented balancing test. Is our interest real? Is sharing necessary for it? And do the individual's rights and expectations outweigh us? That expectations question deserves respect. A customer expects their address to reach the courier. They do not expect their purchase history sold to a data broker. Same data, same company, opposite outcomes on the balancing test. Two final checks before any sharing. Special category data needs an Article 9 gateway on top. And the principles still apply. Share only the minimum needed for compatible purposes. Sharing everything because it's easier is a minimization violation waiting to be found. Here's where data sharing meets the transparency principle we covered earlier and where enforcement actions are frequently born. People have the right to know where their data goes. Articles 13 and 14 require your privacy notice to name the recipients or categories of recipients of personal data. Categories is the practical route for most businesses, delivery partners, payment processors, analytics providers. But be honest and specific with those categories. A notice saying we may share data with trusted partners is the privacy equivalent of mumbling. Which partners? Trusted by whom? For what? Regulators read those phrases as concealment dressed as disclosure. Timing matters too. Inform people at collection, and if your sharing arrangements change later, a new advertising partner, a new data flow, update the notice, and where the change is significant, actively tell people rather than silently editing a web page. Remember our fairness discussion. Surprise is the enemy. If individuals would be startled to learn who holds their data, transparency has failed, regardless of what the fine print technically said. And here's an angle often missed. Obligations attached to the recipient as well. A company obtaining data indirectly must, under Article 14, inform the individuals within a month, covering the source of the data among other details. So if you're the recipient in a data sharing deal, you inherit notice duties, not just data. A quick story. A retail client added a marketing analytics partner but forgot to update their notice for months. No malice, just process failure. The fix we built was simple, and I recommend it to you. Make privacy notice review a mandatory checkbox in every vendor onboarding and every new data initiative. Transparency fails by oversight far more often than by intent. Let's flip the table and sit on the recipient side, because in real life, your organization will receive shared data as often as it discloses it. What lands on you along with the dataset? The key realization: an independent third-party recipient becomes a controller in its own right for whatever it does with the data. Full controller duties, no discounts. You need your own legal basis for your processing, your own privacy notice reaching the individuals, your own security under Article 32, your own retention limits, and your own readiness to honor data subject rights. The data's history doesn't shield you. If the sender collected it unlawfully, your processing doesn't magically become clean, which is exactly why smart recipients ask questions before accepting data. And that's where contracts come in. Even between two controllers, where Article 28 doesn't mandate an agreement, a data sharing agreement is best practice and increasingly expected. It should state what data is shared, for what purposes, on what lawful basis, who answers data subject requests, what security each side maintains, and warranties that the data was collected lawfully with adequate notice to individuals. Think of it as a prenup for data, unromantic, invaluable. One more discipline: onward sharing. The recipient passing data further down the line multiplies risk and dilutes accountability. So agreements typically restrict it or require approval. Here's the scenario I use in training. A mortgage broker receives client data from a comparison website. The broker, who says the website handles all that GDPR stuff, has misunderstood their entire legal position. Once the data is theirs to use, so is the responsibility. When you receive data, you receive duty. Never accept one without pricing in the other. Let's close this chapter by drawing a boundary line on the map, because where your recipient sits changes everything legally. Sharing within the European Economic Area, that's the EU plus Iceland, Liechtenstein, and Norway, follows everything we've discussed today. Legal basis, transparency, contracts, minimization. Demanding but self-contained. The GDPR travels with the data automatically because the same law applies at both ends. Cross that EEA boundary though, and a whole new rulebook activates. Chapter 5 of the GDPR, Articles 44 through 50. Why? Because outside the EEA, the GDPR's protection no longer applies by default. The receiving country might allow government access without safeguards, might offer individuals no remedies. So the law says protection must travel with the data, and you, the exporter, must arrange the transport. That means adequacy decisions, appropriate safeguards like standard contractual clauses, or narrow derogations, all waiting for us in chapters 11 and 12. Here's the trap I most want you to spot: hidden transfers. You didn't send anything abroad, you think, but your German vendor uses a support team in India that can view customer records remotely. Guess what? Remote access from a third country is a transfer. Your backup replicates to a US data center? Transfer. An engineer in Singapore troubleshoots your database? Transfer. The data doesn't need to move house. Someone abroad merely needs the ability to look inside. So build this reflex now. Every vendor review, every sharing deal, ask, where is the data and who, anywhere on earth, can access it? Hold that question, we'll answer it fully soon. First, let's wrap up. Excellent work. Chapter 6 done, and you've now mastered a domain where theory meets messy reality. Due diligence, Article 28 contracts, sub-processor chains, sharing with third parties, and spotting hidden international transfers. These are the skills that make privacy professionals genuinely valuable to their organizations. Before we move ahead, the usual quick checkpoint. If this series is earning its place in your study plan, hit that subscribe button. It unlocks this playlist plus every other certification playlist on the channel, and it's the single best way to support free training like this. Keep the sequence going too. The next 2 chapters cover data subject rights in depth, and they build directly on the controller duties you now understand. When a customer sends an access request that includes data held by your vendors, today's knowledge and next chapter's knowledge shake hands. And when you're ready for structured self-testing, our complete CIPP/E course on Udemy is there for you. Chapter quizzes, full-length practice exams built to mirror the real thing, role-play scenarios like negotiating a DPA or responding to a vendor breach, plus downloadable toolkits. It's the practice layer that turns understanding into a passing score. Link in the description. Take a short break, maybe glance at one of your own company's vendor contracts with fresh eyes, and join me in Chapter 7. The individuals are about to knock on our door with their rights. See you there.